Someone make it make sense.
I'll read a couple.
Good morning, my squirrel friends. Let's get our music going here. La-da-da. Or good evening, I should say, for those of you in different time zones, or good afternoon. Or as they say in Russian, Dobry din. So, hope you guys have had a wonderful week. It's been a long waiting period for this verdict in the Karen Reed trial. But I have a feeling we will have something today, and we will talk more about whatever questions you guys have or comments or thoughts regarding Karen Reed after we go through the latest out of Idaho. And if indeed that brings us up to the court and being in session, we will also pull that up, although typically they just say, hi, okay, bye. But we will check that out as well. If it comes to that time. This hearing is actually kind of short, but it is very important because we have a trial date set, believe it or not. Long awaited, long anticipated. We've all been waiting for it, and I feel like because of in terms of the legal community and whatnot. I think it might have been kind of just missed, which is understandable given the circumstances. So, but we're going to go through it so we can stay up to date. And we do also have a court filing that happened just after the hearing. So we will go over that court filing as well.
All rise. Thank you very much. Please be seated. Good morning, everybody. Okay, let's get on the record, please. Thank you. We are now on the record. This is State versus Bryan Kohberger, CR 2922-2805. Present in the courtroom is Mr. Kohberger, represented by Ms. Taylor, and Ms. Massett and Mr. Logston are participating over Zoom remotely. The state is represented by Mr. Thompson and Ms. Jennings, Latah County Prosecutor's Office, and Mr. Nye and Ms. Beatty are participating over Zoom remotely.
It looks like nothing's working, so that's good.
So we're here.
We are here
for a scheduling order, and I think we're about 13 months from the arraignment. And I think at this point, this is my opinion, that we're getting to a point of diminishing returns.
Yes.
And
he's like, enough is enough, y'all.
Sent to council last Friday on a proposed scheduling order for a lot of things, deadlines, including setting the trial.
And we covered that as well. If you missed that document, I do have a link for that included in the description of this video as well.
And so I also have set this hearing so that we can discuss this and see where everybody is. So let me start with the state. Thanks.
Thank you, Your Honor. We've reviewed the court's proposed scheduling order with the attorney team, and we are agreeable to it. It makes sense that we do the trial in the summertime when high school is out across the street and when the university is out and the conflicting activities. And the schedule that Your Honor proposes is acceptable to the state. I would note just a minor detail that June 19th is also a legal holiday. The court specified July 4th that as a legal holiday, we wouldn't be able to hold trial, but
Sure.
19th as well. Other than that, we have no objection to the court's proposal.
All right. Thank you. I mean, as I went through all of this, I mean, there's going to be a lot of motions, a lot of hearings, a lot of work. There already has been a significant amount of work, as we all know. And when I tried to balance this out, I do think it was it's pretty fair, balanced, and I hope realistic. So, Ms. Taylor.
Thank you, Judge. Your Honor, first, I know the court has listed this as taking place in Latah County. We haven't been heard on our change of venue yet. That's to come.
Totally understand that.
So I don't want anybody thinking I'm agreeing to Latah County as well.
Right.
The June of 2025, that's the time frame that we have been working towards. I am hopeful that we can come in there. We're working towards that date. I think it's reasonable to set that date. As the court's aware, mitigation is something that takes a significant amount of time. We've had that underway since the day we took this case. We continue to work that very hard. I spoke with our mitigation expert last night about this date. And there's a lot of work yet to be done, but we're still working towards that. So I think it's reasonable to set that. I just want the court to know that that's not finished at this point. That's very much ongoing, and new things are coming out that we need to follow up. But with that said, I think it's reasonable to go ahead and pick the June of 2025 as a trial date at this time.
And by the way, I think you understand that, all counsel understand that, but this is a 3-month trial. So I was calculating 2 weeks to set the jury, then 8 weeks of trial, and then 2 weeks for mitigation and sentencing. And I mean, that's a guess, but I think it's enough time for all of those things to.
So just to clarify, so 3-month trial, assuming he gets convicted because of part of that, 2 weeks for the mitigation phase. Now, here's one thing I will note. So a couple things. So Karen Reed, I think there was some discrepancy over if it ended up being 9 weeks or 10 weeks. But remember, there were many weeks where there was 1 week where there was only 1 day in court, other weeks where there were only 2 days, and there were also half days every week. So in terms of total trial time, it actually wasn't that long. He's saying 3 months ish. So, and we also had been talking about with Chad, whenever I'm covering those documents, the differences with his sentencing phase, which Ann Taylor calls the mitigation phase, right? And how, because he waived a lot of that, I know that I was speaking about with the last documents, how typically that process, that sentencing / mitigation phase does last for a couple weeks. That's what we've seen before in other death penalty cases. So what I'm hearing here is what we would normally expect, right? So 2 weeks for the mitigation or sentencing phase. And again, with Chad Daybell, it was just like, a couple hours? And it was really just hearing from the victims before the jury went ahead and filled out that special verdict form and returned the death penalty for him. So this does give like a stark contrast to the difference in how crazy. And again, these trials with being in Idaho, that's the other thing too, because the systems will vary by state, but here it's the same state, and we're seeing what normally would be the case. So 2 weeks
To take care of. And obviously, the last 2 weeks would only be if Mr. Kohberger was convicted. Okay, go ahead.
Thank you, Your Honor. I do want to bring up a couple of issues I have with some of the deadlines. I looked this over. Our team has talked about it. I've gone over this with Mr. Kohberger. I do have a couple of concerns about the deadlines, and I'll just bring those up to the court for the court's consideration.
So on the docket for these different deadlines that they're going to be discussing, there's a lot of things. There's pretrial motions, such as like motions in limine, motions regarding the death penalty. I think jury instructions was on there, change of venue, all kinds of things. So she's about to address her concerns.
As far as motions challenging the death penalty, and that's in right under motion practice letter A that the court has on its draft, we can have a lot of those filed by September 5th. I would note for the court that that's ahead of the state's final discovery date, and that's ahead of the state's deadline to produce its aggravation case that it will use. We can meet this September 5th deadline, but we're going to ask the court to give us a little leeway when there's something new that comes our way. If there's an amendment to a motion or a new motion that becomes relevant based on something new, we'd like a 2-week window after receiving something new to file that.
So what she's saying is we're going to actually be ahead of schedule, Judge, when it comes to submitting these motions challenging the death penalty. However, because we're actually going to be ahead of schedule, we're asking for kind of like a deal, right? Like if we do need extra time for something else, that we can request that as like a trade-off.
But the bulk of it we can get in by the deadline that the court has asked here, and that's just not a problem.
Sure, I understand that. I mean, I looked at that. I wanted to have that early because, you know, it's a bigger question.
Yeah.
And I was aware of the Ross case. I think you had 16 motions in that case. So, I wanted to sort of address those issues early.
Your Honor, we can definitely do that. We can address a lot of things early. We just don't want to be precluded from bringing an amended motion or a new motion if something new is filed that would have been relevant to something we've already filed.
I'm not going to prevent you from doing that.
Perfect. Thank you.
And by the way, a lot of these deadlines, I mean, you can certainly do them earlier if you'd like to. I would encourage everybody to do that. Thank you.
Your Honor, then moving on, the motions in limine under letter C, the court has suggested February 13th as the date for that. I think in large part we can do some by then, but the exhibits that we'll exchange and witness lists that we'll exchange aren't due until after that. And again, I think there might be additional motions that would be relevant after those things have been exchanged. So if the court wanted to move the whole deadline so we had all of those motions in limine at once, I think that would be reasonable. But if the court wants to keep this deadline, as long as we have the ability to bring more motions in limine based on new filings, we'll be okay with that as well.
Sure. And I was also thinking about, I guess experts, for example, I mean, they may have longer hearings that, we're going to have to work through all of these things. I mean, this is just a structure.
Thank you.
Very reasonable.
The court had listed March 14th as a trial brief date, and that is ahead of some of the other deadlines, recognizing that the trial is the innocence phase and the sentencing phase, if it happens, is the mitigation and aggravation. I would just say this is a fine deadline, but we won't be touching anything to do with our mitigation by then, if that's what the court anticipated.
Yes.
Okay, perfect.
I think we had March 3rd for mitigation. I figured by then you would pretty much have that in hand.
Good, we hope to. That brings me to the last point I wanted to talk about. The court has proposed setting a mutual exchange of aggravation and mitigation materials, and I'd ask the court to reconsider that. We will aim for our March 3rd deadline. That's our plan right now. If something changes that, then we'll come back and let the court know and talk to counsel. But would ask that the state's aggravation package be provided to us earlier than the same day as our mitigation. Should we get to that point, the state has the burden of establishing the statutory aggravators. There are some things I think I might be able to guess about how the state's going to try to present information, but I don't think I should have to guess. I think I should have that information well ahead of providing the mitigation that will be presented in response to any aggravating information that's presented by the state. So I'd ask the court to set the date for the state to produce its information much earlier than ours. The state filed its notice a year ago yesterday, and I have a lot of questions about what the state would intend to use to try to establish many of the statutory aggravators they've listed. I know I've heard the court talk about super due process in a capital case, and I think it's appropriate for us to be on notice and be provided discovery, to be provided a full range of what the state intends to use to establish those if we ever get to that point. And I think we need those ahead of our deadline for mitigation. So I'd ask the court to move that deadline up quite a bit earlier. And that's it.
Thank you very much. Mr. Thompson, do you have any issues about having the aggravation in advance for a period of time?
No, sir. As long as we will have the option, ability to supplement that once we see whatever the defense plans to offer in the way of mitigation.
Well, I'm appreciating that, with these deadlines, that we're going to have supplement all the way along.
Right.
I just don't want to be scrambling around a month before the trial. We're all going to be very, very busy. And the more we can resolve certain motions, supplements, whatever we need to do, I'm trying to do this sooner than later.
Yes, sir. And that's our preference as well.
And Ms. Taylor as well.
Yes, Your Honor.
But just to make sure, though, you have to do your job, and the state has to do its job, and I have to do my job. But I think this is a great step, okay, to set these deadlines and hearings so that we can move through this. It's going to take a while, but anything else we need to address today, Mr. Thompson?
I don't believe so. Thank you.
Ms. Taylor?
No, Your Honor. Thank you.
Okay, well, it's very short, and I'm grateful that everybody's working together. Thank you. Okay. Take care, everybody. We are adjourned.
Okay, so next we are going to get to the scheduling order that was filed just after this hearing. Let me go ahead and get my screen sharing, and we're going to go through this document where the actual trial date is then specified. Give me just 1 second. Okay, so all right. So let me actually see if I can do this a different way. Hold on, it'll look better for y'all. There we go. Cool. All right, here we go, guys. Are y'all ready? So here is the scheduling order. So this was filed just after this hearing yesterday in the District Court of the 2nd Judicial District of the State of Idaho and for the County of Latah. All right, we got Idaho v. Kohberger, trial setting. Check it out, guys. A jury trial shall commence at 8:30 a.m. on June 2nd, 2025. So I've got this banner here. Hold on. There it is. It's official. June 2nd, 2025. They've got a date set. And they're going to be starting court at 8:30, which is 11:30 my time. But earlier than most courts, right? Usually they go for 9 o'clock. All right. And it will run until August 29th, 2025, with an 8:30 to 3:30 p.m. schedule. Trial will not be held on June 19th or July 4th. So ostensibly, they'll be having trial the rest of those days, right? These days are inclusive. Okay, these dates are inclusive of jury selection as well as any sentencing phase that may be necessary. The defense's motion to change venue is currently set to be heard on August 29th, 2024. If that motion is granted, the court anticipates the trial dates will not change, although the location of the trial would. That makes sense. All right, a final pre-trial conference will be held on April 3rd, 2025 at 10 a.m. And here's the motions. So any motions challenging the death penalty shall be filed on or before September 5th, 2024. That's kind of coming up. Any responses shall be filed on or before October 10th, 2024. Any replies are due by October 24th, 2024. A hearing on the motions shall be held on November 7th, 2024 at 10 a.m. Motions to suppress evidence and any other 12B motions shall be filed no later than November 14th, 2024. And then here's, of course, also the replies for that, the hearings, motions in limine, which is going to be interesting. Those are always, you never learn about those unless you watch the pre-trial proceedings because they don't come in at trial, right? Motions in limine. And remember, motions in limine can include anything from evidence. It could also be in reference to expert testimony, expert witnesses, things along that. It's things that, but it's to have things completely excluded from trial. With the exceptions of if somebody opens a door, right? So motions in limine, including any 404B. Oh, that's funny because 404B, of course, notices. So just to remind you guys, 404B would be things like prior bad acts, anything that's like propensity, character, testimony, things of that nature. So 404B notices shall be filed by February 13th, 2025. Any responses are due by March 13th, 2025. Any replies shall be filed, blah, blah. Okay, cool. We got all that. So 2025. Discovery. The state's discovery deadline is September 6th, 2024. The defense's discovery deadline is January 9th, 2025. Disclosure of trial experts. A list of experts along with a copy of the expert's report consistent with ICR 16b7 and a copy of the expert's curriculum vitae the state intends to call at trial shall be disclosed to the defense and the court by December 4th, 2024. And a list of experts along with a copy of the expert's report consistent with ICR 16c4 and a copy of the expert's curriculum vitae the defense intends to call at trial shall be disclosed to the state and the court by January 9th. So again, this is this first one, A, right, is for the state. The state has to disclose to the defense by December 4th for experts. And then as far as the defense, they have to disclose their experts to the state by January 9th, 2025. Any rebuttal experts for either the state or the defense must be disclosed by January 30th, 2025. Trial materials. Proposed jury questionnaires shall be provided to the court by February 7th, 2025. That's going to be interesting. I hope we get to see that. Responses must be filed by March 7th, and then ICAR, Idaho Court Administrative Rule. That's probably why I said court earlier, because we've covered ICAR extensively. A closed sealed hearing on the jury. Great. Well, that answers that question. We won't get to hear it. A closed sealed hearing on the jury questionnaires will be held on April 2nd, 2025 at 10 a.m. Proposed jury instructions shall be filed with the court by March 14th, 2025. Jury instructions will be discussed at the final pretrial conference. So then we'll get to hear that discussion at that time. Oh my God, Blackwater. Lay witness lists shall be filed by March 14th, 2025. Exhibit lists with attached copies of exhibits shall be filed by March 14th, 2025. Each party shall prepare a list of exhibits that it expects to offer, including impeachment documents to the court and to opposing counsel. Exhibits should be listed in the order that the party anticipates they will be offered. Each party shall affix labels to their exhibits before trial. Yeah, great, because that should help move things along when they go to admit into evidence. The state's exhibits should be marked with red labels. This is brilliant. A numerical sequence with an S before the number. Defendant's exhibits should be marked with blue labels. A numerical response with a D before the number. Love it. Love this. The case number should also be placed on each of the exhibit labels. Exhibits should be lodged and served as required by its pretrial order. Exhibit labels can be obtained from a deputy court clerk. Counsel shall provide a copy of each exhibit and an exhibit list to opposing counsel and the court. Copies should be made after the labels are marked and attached to the original exhibit. To expedite the trial, each exhibit to be offered should be reviewed by opposing counsel prior to trial and a determination made as to whether an objection will be lodged against the exhibit. So whenever we hear in trial things like they're like, yeah, no objection from the other side, like they say that ahead of time, it's because of this, right? So of course there can always be objections that come up in trial, but this should expedite it, right? So that essentially anything that's already made it this far has passed a certain threshold, right? That there's not going to be issues, at least already anticipated issues beforehand. An exhibit to which there's no objection will be admitted prior to trial. Excellent. So this is like stipulating, right? A lot of this might be with things like just your basic chain of custody. Remember, like with Murdoch, that was an interesting situation because the defense did not stipulate to any of that chain of custody, which, as I've remarked before, was maybe a bit tedious to watch, right? However, the beautiful thing was we actually got to fully see what the chain of custody looks like, and we don't always see that because they stipulate. And now, as we come into Karen Reed and all that, or well, finishing up, but it really gives you a really stark contrast, right, as to what all was not done there. But in other words, more than likely things will be stipulated to a certain extent. So then it'll be admitted prior to trial. That speeds things along. Each party shall provide the court with a trial brief, which shall be filed on or before March 14th, 2025. Sentencing disclosures. Any witness, lay or expert reports, and a list of exhibits with copies attached. The state intends to present in support of aggravation. So this is when it comes to the death penalty, okay? Aggravating factors. Shall be provided to the defense and the court by January 9th, 2025. Defendant's mitigation, and I love that he's using Ann Taylor's word here, because again, usually we call it the sentencing, right? He's using Ann Taylor's word of mitigation, which I love. Defendant's mitigation disclosures, including a list of witnesses, lay and expert reports, and a list of exhibits with copies attached, shall be provided to the state and the court by March 3rd, 2025. Any witnesses, lay or expert, and exhibits the state intends to present in rebuttal shall be provided to the defense and the court by March 31st, 2025. Filings after the deadline. The court reserves the right to hear any motions filed after a deadline has passed if good cause is shown, including but not limited to motions that arise after disclosure made by the opposing party. So this is kind of what he was saying, right? Like he expects supplemental filings to come in, and like what Ann Taylor was saying. So in other words, if a deadline is passed, they can have make a motion, they can have a hearing, they can talk about it and decide whether or not it's too late, too bad, so sad, or it should come in or not. I love his signature. I know I say this every time. Signed, Judge, as of yesterday. So you guys, we have a trial date. There it is, June 2nd, 2025. There we go. So at this point, okay, cool. So there you have it, guys. That's the latest out of Idaho. I did check again right before this live stream. There was nothing else new for this case, but we will have court in session pretty soon here for Karen Reed. And I do have a feeling that we will have a verdict today, which works out because I was really hoping in a way that they didn't return one yesterday because I had a lot of lessons, but I will be available and I will be monitoring the situation all day today on standby. But I do have a feeling that we will get a verdict today. Thinking it through, right? Like it would make sense that when they started deliberations on Tuesday, they didn't have that much time. And I would imagine they had a lot just to talk about, right? Like we've heard in other trials, for example, Chad Daybell, where their first discussion was like, oh my God, can you believe this and that? And like the zombies and all the rest, right? The storm, probably. The craziness of it all, right? Because they haven't been able to talk. So I would imagine that was Tuesday. And then I would imagine they didn't actually get into it, the deliberations, until Wednesday. And, we've heard from other jurors that come out and talk and give interviews if they so choose after the fact, that even in cases where they were all in agreement, they still felt the need to go through each charge. Now, if you look at somebody like Murdoch, the charges were pretty simple, right? The verdict form and the charge, it was all short. It was just cut and dry. With this one, though, that's not really the case because we have these lesser includeds, right? So you've got 3 different indictments, and then there's different options within that, especially the second charge being probably the most complicated, which is the operating a motor vehicle, manslaughter while operating a motor vehicle under the influence, has those different options there. So, so the more that you have with the verdict form, right, it would make sense that even if you're already in agreement, let's say it's not guilty, just for the sake of the example, that you might still feel the need to go through each charge, right, and talk about it and give it the time that you feel it deserves when it's been a lengthy trial, and to do your due diligence there out of respect, essentially, if you will. And we've heard that from other jurors with other cases, even when they were already kind of on the same page. So I think that in this case, that could be part of what was taking so long, what has been taking so long. I wouldn't be surprised if they had a full day on Wednesday and a full day on Thursday. Let's say that was what they needed to go through it all, but then they wanted to sleep on it, right? And we do know they also had the one juror that needs to leave early to catch the bus or whatever. I could see then them coming in this morning being like, okay, everybody's still good. All right, cool. And coming back with a verdict this morning. I could see that. I would be shocked, though, if they don't come back with a verdict today, and here's why. Because it's a weekend coming up, and we do have a holiday. Actually, when is July 4th? Let me see. Holiday week next week, but for a lot of people, they might have plans. That's next Thursday, July 4th. But especially with a weekend and then a holiday week coming up, I would be really surprised if they don't return a verdict today. I'll quickly just go over like what happens if it's a hung jury. So if it's hung, right, what'll happen, and I don't anticipate this, but if it happens, they come back to the judge and say they can't get a verdict, can't return a verdict. The judge will give them the Allen charge, which is basically saying, go back and you guys are awesome. Y'all can do it. You can do this. It's like a pep talk, right? No one's better than you guys, blah, blah. And then they will try again, right? And I've seen it before where they give the Allen charge a couple times, like in YNW Melly. I think they were given the Allen charge maybe 3 times before they were like, yeah, sorry, not happening, right? And then it was a mistrial. So, but I've also seen it where it's just given once and then that's it. So that I would imagine with Judge Bev, I could see her giving it more than once. But if indeed they've been given the Allen charge one or more times, and they still cannot return a verdict, then it's a mistrial. So in that case, what happens? Well, in that case, double jeopardy does not attach. So when does double jeopardy attach? Double jeopardy attaches when a verdict has been reached by either a judge, so for example, in a bench trial, or like with a plea deal, right? Or a verdict from a jury. So that's when double jeopardy attaches, okay? And same thing with an acquittal. An acquittal can only happen when there's been a verdict reached by a judge or a jury. So in this case, if there's a hung jury, and then indeed we have a mistrial, Karen Reed is not acquitted because there was no verdict. It's essentially as if this has never happened. And basically, what then would be the case is that it's a mistrial. So it's as if she was just, that's it. So she's not found guilty or not guilty. It's just the state has the option, because jeopardy does not attach, the state, or the Commonwealth rather, would have the option to bring charges again, but it's starting over. They have to bring the charges again from scratch, as in going back to getting indictments from a grand jury, right? If they choose to go that route again, and presenting them and all that, and it's literally starting from scratch. So so essentially it would, and the entire thing would start over. Oftentimes when you have a mistrial, the decision from the state, or in this case, the Commonwealth, to bring charges again or not would depend on if they can get an idea for what the vote was with the jurors being hung. Now, I don't actually know how they really find that out, because the deliberations are, private or whatever. Now, the exception, of course, is that the jurors choose to talk. They can say, how many were for or against, whatever the case may be with the verdict, and how specifically they were hung, right? And if it was just one holdout or whatever, then it's likely that the state, or in this case, again, the Commonwealth, would choose to bring charges again. But that would it really all just depends, right? In this particular case, I don't think the charges should have been brought to begin with, as you guys are well aware, and I know I'm not alone in that sentiment. And I think the Commonwealth would have to be absolutely out of their minds to do it again. I would be shocked if they did, especially if they are privy or keeping up with anything that anyone else is saying, even within the legal community, that this is an absolute miscarriage of justice. And add to that they're being investigated by the FBI. So, the Department of Justice. So, that would be wild to me if they did bring charges again. I think the worst case scenario for Karen Read is a mistrial, is a hung jury. And I say worst case scenario because I think she's going to be found not guilty of all the charges. But if it is hung, again, it's a mistrial, and then she gets to go back to her life, and the Commonwealth can choose to bring charges again or not. And again, like I said, I don't think they would. I would really hope they wouldn't. So one thing I will note that I think is interesting is this thing about the juror with the bus, because that was not an issue during the trial. It wasn't until deliberations started that they had to leave by a certain time to get the bus. I don't know if that's a coincidence or what, but it is interesting, that that was not an issue during the trial, because they went, 4:30. I think there might have been one day where they went to 5. So, but apparently now they need to stop by 3:30. So, so I will be monitoring all of that. And I will have the court feed open on every screen imaginable in case that fan moves. And so I have the live stream set for, I think I set it for 4 p.m. because that would be like potentially the latest, right, possible today. But just keep an eye out. I will change that, obviously, when we know there's a verdict, and I will keep you guys updated if I hear anything also in the Discord. But I'm going to be just monitoring that all day. And like I said, I do anticipate a verdict. So anyway, so that's the latest out of Idaho for Kohberger. We have a trial date, June 2nd. It should be expected to go until, what did he say? End of August. Let me see. Yeah, end of August 29th. He's expecting June 2nd to August 29th. And the start date does include jury selection. So they're expecting 8 weeks for the trial, 2 weeks for the mitigation. And so the math there would mean 2 weeks for the jury. Like they're expecting 2 weeks for jury selection, right? 2 weeks for jury selection, 8 weeks for the trial, and then 2 weeks for the mitigation phase if he's found guilty. And that totals the 3 months that Judge was referencing. So that just about does it for now. And hopefully this all is helpful to you guys to be kept up to speed with this. But yeah, that's it for now. So I will be on the lookout for a verdict, as I've said, and I will go ahead and roll that outro. Thanks for being here, and thanks for being a squirrel. See you guys soon, hopefully, for a verdict. We're Karen Read.